Introducing David Friedman. David Friedman is an academic economist with a doctorate in physics who has spent the past 22 years teaching in a law school. His first book, The Machinery of Freedom, Guide to a Radical Capitalism, was published in 1973 and includes a description of how a society with property rights without government might function. There, as elsewhere, he offers a consequentialist defense of libertarianism. His most recent nonfiction book, Imperfect, Technology and Freedom in an Uncertain World, examines the implications of a variety of technological revolutions that might happen over the next few decades. His current book project, not yet published, is Legal Systems Very Different from Ours, covering systems from Periclean Athens through modern Amish and Romany. Ladies and gentlemen, David Friedman.
So I gather it's set up so I can either face you or see what you're seeing, but not both. This is not a good design. There is a standard modern model of law which everybody takes for granted. In that model, assuming my clicker works, which it doesn't seem to be, I'm supposed to be getting the next slide. I am not getting the next slide. Now it did. In that model, law is made by the legislature or by judges. Detection and prosecution of offenses is public for criminal law, private for tort law. Disputes are resolved in government courts, and verdicts are enforced by government. It turns out that there is a different model, which is historically fairly common, in which law enforcement was private and decentralized. There is some evidence that most legal systems started out that way, that most surviving legal systems were built on top of this model, and in some forms it still exists. And the one thing I always want to warn people about when I talk about feud law is that the word feud has no connection to the word feudal. They happen to sound the same, but their meaning is different and their origin is different. This is not a good clicker. If I click several times to get it to happen, everything goes, including the things that are supposed to go one at a time. All right, maybe I've got to push for it. The logic of feud law goes as follows. If you wrong me, I threaten to harm you unless you compensate me. In order for it to work, there are 4 problems it has to solve. Fifth problem is making the clicker work. It needs some mechanism so that right makes might. There's got to be some way in which my threat to harm you is believable if you really have wronged me and is not believable if you haven't. Otherwise, it just becomes extortion. You need some way of making me go through with my threats. That you wrong me, I threaten to harm you if you don't compensate me. Your reply is you try to harm me and I'll kill you. There's got to be a reason why I still try to harm you. If I back down, the system doesn't work. We not only need a commitment mechanism, we even need a commitment mechanism that works through death. We need some way in which if you wrong me and I make a claim against you, you can't solve the problem by just killing me. We need some mechanism to protect people who are too weak to believably threaten retaliation. So if the victim of a wrong does not himself have access to people who will fight for him, we need some way of defending him, some way of getting him revenged, as it were. And finally, we need a way of ending feuds. That when people talk about feud, they usually imagine a back and forth going on forever, where I kill some of your people, then you kill some of my people, and so forth. Historically, that doesn't seem to be the usual pattern. There's a very famous feud in American folklore, which is people see this way. And if you actually look at what happened, a total of 4 people are killed. There is then peace for something like 5 or 10 years until the state government intervenes and restarts the feud. If you look at the feuds in saga period Iceland about 1,000 years ago, most of them end at about the first round or the second round. But you could imagine a feud going on, and we need some way of preventing that. So those are the things we need, in addition to a clicker that works. Do you have another clicker somewhere? I'm pushing this thing, and once in a while it buzzes at me, and then something happens, but mostly it doesn't buzz at me, and nothing happens. Works for him. Does it matter where you're standing?
You gotta stay closer to the computer.
Where is the computer? That's the computer. Now they tell me. All right. There is a computer hiding behind this screen in case you can't see it. So how do we arrange that right makes might? How do we arrange things so that if you're guilty of my charge, it works, and if you're not guilty, it doesn't work? Do you have another of these? Saga period Iceland, they actually had a fairly elaborate system of legislature and law courts. What they didn't have in that system was any government official for enforcing the law. So you got your verdict, and it was up to you to enforce it. So what that meant was that after you had won the case, and the court said that somebody owed you 300 ounces of silver for having killed your son, this stage doesn't like me. It's targeting me, damn it. So after I win my case, the court says you owe me 200 ounces of silver in weregeld, the damage payment for killing somebody. If you don't pay it, the court outlaws you. Once you are an outlaw, it is legal for me to kill you, and it is illegal for anybody to defend you. So if people try to defend you and get into fights, every time anybody is hurt, they owe damage to someone, to the relatives of those people. And thus, if you try to defy the system, we will see. If you try to defy the system, the coalition against you grows. So in that case, it was the actual court system that made right make might, not because there was the government providing you with policemen to arrest people, but because your neighbors knew whether you were the good guy or the bad guy. Now let me go back. The Roman child gypsies who currently exist, this is the largest Romany group in England at present, and they have what's essentially a primitive version of the Icelandic system of 1,000 years earlier. That, as described by people who've looked at it, what happens is that if I wrong you, you threaten to beat me up unless I compensate you. And it's a small enough community so that the people around probably know whether you really wronged me or didn't. And if you really wronged me, then my friends will back me and your friends won't back you. And if you didn't, it goes the other way around. So what makes right make might in that case is, again, the willingness of other people to support the good guys against the bad guys. Somaliland, northern Somalia, has had a traditional system for stateless rights enforcement. And in that one, there's a traditional law code, which is partly coming from Islamic law and partly from local traditional law. and there are mechanisms by which, when there's a dispute, you can set up an ad hoc court, the court gives a verdict, and then people go along with that verdict. All of these mechanisms solve two different problems. One of them is preventing the use of threats for extortion, which is an obvious potential in this kind of system. But the other is to prevent individuals from acting as biased judges in their own case, because we are all tend to be prejudiced in our own favor. And by bringing in a third party, whether the Icelandic court or the local members of the Romanchal community or the ad hoc court in Somaliland, all of those, somebody other than the parties is deciding whether you're in the right, and unless they decide you're in the right, you will be unable to use force to vindicate yourself. The next problem is a commitment mechanism. How do we make sure that people will actually carry through their threats when the other person obviously says, I will beat you up if you try? And it turns out that one solution to this problem predates our species. People will sometimes tell you that property is a creation of government. So you shouldn't really object when the government taxes your stuff because it's only your stuff because the government says so. In fact, we know that property existed long before the human race. What's called territorial behavior in animals is a primitive version of property. And the way it works is that an animal, usually typically a bird or a fish, so there are some territorial mammals, a territorial animal marks a territory it's claiming and then somehow turns a switch in its brain, as it were, such that if another member of the same species trespasses, the defender will fight more and more desperately the farther into his territory the trespasser comes. Unless the attacker is much larger and stronger than the defender, a fight to the death is a loss for both. Even if the attacker wins, he's likely to get injuries that cost him more than the trespass is worth. So once you realize that the defender is committed to defend, it pays to back off. And that's what usually, though not always, happens. So that's a case of pre-human commitment strategy done somehow biologically. Humans have something similar. We call it vengefulness. People think of vengefulness as an irrational emotion, but in fact it's a rational emotion. The knowledge that if you hurt me, I will go to a good deal of trouble to get back at you is a reason not to hurt me. It may be a dangerous reason, but it is a reason. It serves a function. And so one of the reasons my threat is believable is that after you have wronged me, I'm going to very much want to get back at you unless you compensate me. But then there are various external commitment mechanisms that humans have. I deduce that the problem's with the receiver, not the transmitter. We've done this experiment. One of them is that you want the reputation that when people wrong you, you act against them, because otherwise people will feel free to wrong you. So that's one reason to carry through your threat. The problem is that I press it several times. When it finally notices, it goes backwards. All right. Second reason is that humans care a lot about status. And if you cut trees in my land, on my territory, or take my stuff, or do something else that I regard as a wrong, and I threaten and back down, other people will see me as a wimp, and people don't like to be viewed as wimps. Furthermore, that success gains status if you successfully act against the person who wronged you. And in fact, you get evidence in both Icelandic, that is, this is Saga period Icelandic society, and in Comanche, which is another stateless society, one of the Indian tribes, that you sometimes get volunteer defenders, where somebody who is relatively weak has been wronged, and some big, strong person says, I'll take care of it, because he wants to get the status of proving that he can face down the person who wronged him. How do we enforce our rights after we're dead? It's true that after I'm dead, I don't much care about my rights, but the knowledge that if you kill me, bad things will still happen to you is a reason not to kill me, and that I do care about. So the answer is, one answer, the Icelandic answer, is that your kin enforce your claim, and they want to enforce it both to collect the damage payment, which is a lot of money, and to make sure that other members of their related group don't get killed, because it's clear bad things happen to you if you do. The Somali solution is a rather complicated and interesting system in which everybody is a member of a set of nested, preformed groups. And the membership of the groups is determined in part by kinship and in part by contract. And the function of the group is to enforce its members' rights. So that's one of the functions. So that if you are wronged and you demand compensation, your dia-paying group will help you get it. If you owe compensation, they will help you pay it. And if you are paid compensation, they will collect some of it. So it really is a voluntary arrangement for groups of people agreeing to mutually help defend each other. So those are both solutions. That time I didn't even push the button. How do you protect the weak? My favorite solution to protecting the weak. How do you protect the weak when they have bad clickers? Now, this time it's wet. All right. The Icelandic solution is that tort claims were marketable. So I'm an elderly man and I have one son and somebody kills him. This is in Iceland 1,000 years ago. And I know that if I try to go to court and sue him, I'll get beaten up on the way to court. But my neighbor is a wealthy farmer with 4 big tough sons who went a Viking in their youth. I transfer the claim to him. He collects my 300 ounces of silver, and if it was easy to do, he gives me some of it, and if it was hard to do, he keeps it. But either way, the person who killed my son is paid for killing him, which is a reason not to kill people, even when their only relatives are weak. So by making tort claims marketable, you have a way in which people without resources can still get their rights enforced. And I have argued for some time that the U.S. legal system should adopt this, and that indeed this is a respect in which modern American law is a mere 1,000 years behind the cutting edge of legal technology. Somali solution, I already mentioned. You have dia-paying groups formed by a mix of kinship and contract. You're a member of the group, and so the members of your group will help you defend it. How do you end feud? What happens if I think you wronged me and you disagree? So naturally enough, I demand damages, you refuse to pay damages, I harm you. You now think I've wronged you, so you demand damages for me, and you can imagine that going on for a long time. The Icelandic solution, the usual solution, is we find a third-party arbitrator. We pick somebody who is powerful and respected, and both of us agree to accept his verdict on the feud. Because until we do that, each of us feels that if he gives in, he looks like a wimp. Once we've done that, now if the arbitrator rules against me, well, that's what I agreed to. The arbitrator is a neutral party. I'm not a wimp for following through on my agreement. And if the arbitrator rules against me and I refuse to go along, I've just added a new powerful enemy to the other side, which I don't really want to do. So that is a solution. My favorite Somali solution as an economist was a point at which two groups were having too much killing, and so they raised the price. Two sides both agreed that the amount of damages you had to pay for killing somebody would go up. As an economist can tell you, when you raise the price of something, people buy less of it. The Finnish gypsy system, the Kale, who are one of the weirdest societies I know of, and there the basic solution is that when you have a feud, you avoid the other group, and you keep avoiding the other group until everybody's forgotten what it's about. which may take a while. I think I went through that already. All right. Yes. So I want to claim that many modern legal systems started out that way. Anglo-American common law grew out of Anglo-Saxon law, which was basically Icelandic law plus a king. The king claimed that some offenses were offenses both against the victim and against him. If you killed somebody in the king's hall, that was a violation of the king's peace. Gradually, the exception expands to swallow the rule, and by early Norman England, the king has in effect grabbed the revenue from the damage payments from killing people and injuring people. Rabbinic law, which is possibly the best documented old legal system, there is evidence of what I think of as fossilized feud. That under rabbinic law, if you kill somebody, you are supposed to go to one of the cities of refuge, be escorted from there to the court in the in the city where you killed him, be tried. If it is determined that it's the equivalent of first-degree murder, you are executed by the avenger of blood. Who is the avenger of blood? The heir of the man you killed, the person who in a feud system would have been responsible for pursuing the feud. If it's determined that it's a lesser form of killing, you go back to the city of refuge. You remain there until the high priest dies. It's an exile of indefinite term. And if the avenger of blood catches you on your way, he can kill you. Furthermore, it is illegal for the avenger of blood to accept a money payment for not killing you. You make laws against things that people do. So that looks as though they had a feud system and they then changed the rules in order to incorporate it into a legal system. And there is also some evidence, which I'm not going to go into, of that claims were self-enforced. Islamic law, fiqh, includes a part called jinayat, which deals with killing or injuring people, in which it is treated as an offense against the victim or his kin group, not against the state. What then happens is that the kin group, again, for the equivalent of first-degree murder, they've got the option of retaliation, of killing the killer, but they also have the option of accepting diya, which is the damage payment for a killing. And in the case of a less than first-degree murder, they can't retaliate, but they do get to collect a damage payment. Now, I should say there's also an obligation to God. You're supposed to free one Muslim slave, I think, or fast for 2 months. But there's no obligation to the state in traditional Islamic law. Roman law, it's a little unclear because the basic document of Roman law hasn't survived. We only have fragmentary information, but it looks as though the 12 tables refer to self-help remedies, which sounds as though they're coming out of feudal law. And in the early republic, it was up to the plaintiff to drag the defendant to court, and the result of the verdict was they had the right to seize, sell, or execute the defendant. So all of those systems look as though they started out as feud law and were then built on top of it. Chinese law I haven't figured out yet. Modern forms of feud law. There's quite a lot of informal feud law under the shadow of state law. I think I'm running out of time, so I may not finish this part. The Roman Chal I already mentioned, where you have feud law happening in modern England. The Sicilian Mafia would be an example. And within the state legal system, suing somebody who was innocent is a wrong, and a suit in response is retaliation. In particular, my standard example of this, patent infringement litigation. Apple would like to sue Samsung. Let's imagine that Apple thinks that probably Samsung did not violate Apple's patents, but patent law is very complicated, so they might win. And even if they lose, while the case is going, people won't want to buy Samsung phones, so they'll buy iPhones instead. So it looks as though it might pay. It looks as though it might pay Apple to sue, even if they're in the wrong. The trouble is that Samsung can also sue Apple. So that's retaliation. And that means that it only pays Apple to sue if they have a reasonable chance of winning. So that's a case in which the mechanism for making right make might is the court system. There's a problem. The problem is what they refer to as patent trolls or non-practicing entities. Suppose you have a company that buys up patents but doesn't use them. The reason they buy up patents is to sue other people on the claim that they're infringing the patent. You can't countersue because they aren't practicing any patents that you could claim, or they aren't doing anything that you could claim violates your patent. So the patent troll says to a not very large company, we think you're violating our patents. We might lose the case, but it'll cost you a lot of money to fight the case. We might win the case and you're bankrupt. How would you like to pay us a modest licensing fee instead? So it's a scheme, arguably, for extortion. And it works because the patent troll is immune to retaliation. I have a solution from Periclean Athens. This is not feud law, but my Legal System's Very Different book covers all sorts of fun things. And in Periclean Athens, the legal system for at least some tort cases, we don't know if for all of them, provided that if you sued and lost, you owed damages to the person you'd sued. You, in fact, owed him a sixth of the amount that you had claimed he owed you. So you can think of that as a damage payment for suing an innocent party, because when you sue an innocent party, there's a risk, since courts make mistakes, that he'll lose and you'll get money from him. So you're imposing a probabilistic injury on him, so therefore you should owe him money. And that's all. No. Yeah. Go forward. Right. So, all right. This was somewhat more disconnected than usual because of technical error. However, if you want more information, that's my webpage, daviddfriedman.com. And it's got on it the draft of the current book project, and you can learn lots of stuff about feud law, Somaliland, which is a neat and interesting place, Saga period Iceland, which is the first such system I looked at, Periclean Athens, which I like to describe as the legal system of a mad economist, for various reasons, and so forth. I've never really liked PowerPoints anyway. I should have given this talk without them. Thank you.